A criminal defendant is entitled, as a matter of constitutional right, to have a reasonable bond or bail established for pretrial release. So the real question for the court is there a substantial reason to modify the original bond as set?
No one is willing to vouch for the defendant.
And I spoke to the person who provided a letter to the court, who is also a pillar of the community.
That individual in the letter wants to remain anonymous. How is that considered a voucher or a support for the defendant?
She paid for a Lyft ride to the Oakland County Sheriff's Office to turn herself in to talk to the officers. I don't think I've ever had a client who actually paid for a share ride to go turn themselves into the Oakland County Jail.
While she was cooperating with law enforcement, defendant was not accepting or acknowledging what she did. Ms. Bryant abandoned the victims in this case in an unlivable residence.
My position is that the only time that the court could do a cash bond is if the court finds either that she's a flight risk or that she poses a danger to the community.
But I'm going to reduce the bond to a $50,000 cash bond at this point with the following conditions. The defendant will be on pretrial services supervision. There's to be no alcohol or illegal drug use, no possession of a weapon, no assaultive conduct of any sort while this case is pending, no contact with any child under the age of 18, absolutely no contact with the alleged victims in this case. I am going to impose a home confinement electronic monitoring device. Be aware that if you violate any condition of release, you would be subject to arrest without a warrant and may have your bond forfeited, revoked, new conditions imposed in addition to any other penalties if you are found in contempt of court.